Hello, everybody. I hope you're doing well today. I'd like to introduce myself and welcome you to this morning's webinar on labor negotiations. This webinar is one in a series of webinars addressing topics aligned with the School of Professional Studies Masters of Science program in Negotiation and Conflict Resolution. My name is Andrew Hummer. I'm an advisor in the School of Professional Studies, and I will be facilitating some of the conversation today. If you're able to hear me, please type yes into the Q&A box. We want to make sure that we can all hear our presenters loud and clear before we go ahead and dive in. So it looks like you guys can hear me. Great. So I'm going to encourage you to utilize the Q&A function as you develop questions during the presentation. At the end of today's session, we will be addressing some of those questions you share with us today. We will not be using the chat box function for this webinar, so please let us know of any questions via the Q&A box. I'd also like to share that today's session is being recorded and will be made available to you for your convenience. At this time, I'd like to introduce you to today's presenters. Joining us today is Dr. Beth Fisher-Yoshida, Academic Director for the MS in Negotiation and Conflict Resolution, and Michael Chwick, who was the lead contract negotiator for the City of District of New Rochelle for about 15-20 years and is currently an attorney. So welcome. Hello, Beth. How are you doing today?
Hi. Thanks, Andy, for the introduction, and glad to have Michael with us in the webinar.
Yeah. Hello, everybody. I'm glad to be here as well.
Super. So if we can just go to the next slide, I just want to set the context by talking a little bit about approaches to conflict, and then Michael will talk more in depth about labor negotiations. So we see here there is a continuum, and on one side, on the left side, it has a lot more direct participation by the parties themselves, and they're much more in control of the outcomes or the decisions being made. And as you go along the continuum towards the right, you see that the parties themselves are less directly involved in whatever kind of dispute resolution process is going to take place. And that means they're one step or more steps removed from the decision-making process. They may be able to influence the outcomes, but they're not completely in control of it. And so if we really think about the fullest extent of collaboration and being able to listen to each other, have empathy, really understand our own needs and the needs of the other party, then the more likely we are to be able to engage in negotiation and in maybe potentially mediation, where you start to introduce a third party neutral. Neutral meaning they're not directly involved in that particular conflict, but they're there to facilitate or guide the process along. And then, of course, to the right is less and less so. It's more removed. And so labor negotiations are a different kind of negotiation. And I'm going to turn it over to Michael now to talk more in depth about his experiences in labor negotiations. And we'll look at it maybe in comparison to this continuum at some point after his presentation. And we will have a little bit of a discussion and then be happy to respond to your questions. So Michael, I'll turn that back over to you now.
Thank you, Beth, and thank you for inviting me here and allowing me to share my experience as a labor negotiator in this webinar. Before I even move on to the next slide, I can tell you that this continuum really speaks, truth. When I was an attorney, I tried to counsel my clients to stay as far away from the right side of the continuum as possible. Litigation is time-consuming, it's expensive, and as we all know, the principals in the dispute don't get to decide their outcome. When I was a labor negotiator, I spent my time mostly on the left side of the continuum, and hopefully never, deviated past negotiation. Mediation would even have been considered a bit of a failure at that point. So let me tell you a little bit about myself. Actually, let me keep it here for a second. I practiced law for about 10 years exclusively and realized that wasn't something that I wanted to do for the rest of my life. So I sort of reinvented myself, and I went back to school and I became a high school social studies teacher in a public school district. In this case, it was New Rochelle. But no sooner did I begin teaching than a group of teachers who knew that I had been an attorney first approached me to get more involved in the union. I really didn't know all that much about public sector labor union or labor law, education law for that matter. And I declined, but I also declined because I wanted to spend the first few years in my new career learning how to be a better teacher. I was able to sort of fend them off for a few years, but eventually I did agree to get more involved in the union, and I was selected to be the chief negotiator for the union. Officially, the title was chairperson of the negotiations committee, but it often fell to me to take the lead and lead the negotiations. The union that I represented was actually an unusual one for a school district because we had 1,300 members, and the membership included pretty much all the titles in the school district. So of course there were teachers and teaching assistants, but we also represented all of the titles that would have normally been in a more traditional civil service bargaining unit. The only people who were not part of our union were principals, assistant principals, and their confidential assistants. But other than that, everybody was in the union. It was a very, very diverse union, obviously teachers, but all the way to secretaries and electricians, plumbers, any title that was an employee of the school district was in our union. And that, of course, presented all kinds of challenges because the interests of, teachers are not necessarily always aligned with the interests of nurses, and the interests of carpenters always aren't aligned with the interests of guidance counselors. So one of the initial, sort of challenges we always had was to get consensus among ourselves before we even got to approach the management or the school board representatives. So let's take a look at what we're going to do today as a sort of a brief agenda to sort of outline what's going to happen. We're going to spend a little bit of time just looking at, what public sector labor unions are. How are they different? How are they, unique? What special challenges do they pose that maybe private sector labor unions don't? After that, we're going to move on to look at, better word than brief, is a quick history of public sector labor unrest in New York, mostly New York City, in the 1960s. And that's important because what it led to was the enactment of the Taylor Law, which is the guiding statute for public sector labor unions, labor management negotiations and in New York State. So we'll take a brief look, not a law school look, but sort of a primer on the Taylor Law. And then we're going to take two parts out of the Taylor Law that I think are appropriate to talk to both in the context of public sector labor unions and really any kind of negotiations or conflict resolution, and that is achieving good faith in negotiations and how to resolve impasses. So with that, let's get going. Okay. Many of you know that over the last year, there were several teacher strikes across the United States. There's actually one sort of going on right now in Denver. But about a month ago, when I put these slides together, we were in the middle of the Los Angeles teachers strike. They went out on strike, and of course, students weren't being educated, which is the primary mission of a school district. So sure, there's that to consider. But also remember, try to put yourselves in sort of the position of a parent. You have very, very young children. How are you going to rearrange your life to provide daycare for them? If you're the parents of teenagers, perhaps, what are you going to do to make sure that they don't get into trouble when they're not being supervised in the afternoon? So I guess the point of this is when you're dealing with a public sector labor union, you're really talking about, governmental services that people come to rely on. And then suddenly when those services aren't being provided, there's a problem. So they're a little different. So let's take a look at some of the different categories that would be public sector employees. Obviously, there are teachers, and everybody, thinks about, police officers and firefighters. They sort of keep the public safe. We wouldn't want them going out on strike or exercising any kind of work slowdowns. We want to keep labor peace with them. Very often in cities, sanitation workers are part of the uniformed public servants. Of course, we don't want garbage piling up on our streets, but of course, if there is, then we have a public health hazard as well. In New York City, for example, The sanitation department also provides snow removal. So anybody who was in the city just a couple of days ago knows how important it is to keep that union happy and working. Other public sector labor unions that we come to expect, bus operators and train engineers. We know that if they go on strike or if they're unhappy, how disruptive that could be in trying to get to work. But really, anybody who works for a municipality, a city, a village, a school district is part of a public sector labor union in New York State. So it could be anybody from nurses and engineers and inspectors, pretty much anybody. Now, within each of these unions, there can be division as well. So as I mentioned earlier, even though in New Rochelle we were all part of one union, that's kind of unusual. Typically, teachers and teaching assistants are in one bargaining unit, one union, but others, like more traditional, say, blue collar trades, are in a different union, like electricians, carpenters, and things like that. So you're not always talking about a monolithic thing. In New York City, the rank and file patrolmen and patrolwomen are part of the Policemen's Benevolent Association, the PBA, but their sergeants are in a different union. And that would be very similar in other of these titles as well. Okay, some more basic information before we sort of jump into this. Let's see, okay. First of all, states can differ on their treatment of public sector labor unions. So as we just mentioned, for example, California permits teachers to go on strike. New York does not. As we'll see in a bit, under the Taylor law, no public sector employee is permitted to strike in New York State. But in California and in other places, that's true. Number two, not all public sector labor unions are treated the same. So while teachers are permitted to strike, we really never want policemen to strike. So that would be something totally different. Also, the impasse resolution procedures. So when you're negotiating and you get to a point where it's difficult to move forward, the parties have reached deadlock, what can the state, what can the government do to sort of nudge the parties forward? Depending on the union in New York State, the type of union, teacher versus a police officer, the government can do certain things to nudge forward, and there's differences from one to the other. And then third, although it says number two here, public sector union power has changed over time. Sometimes public sector unions are very powerful, sometimes their power wanes. And we can see that in last year's Supreme Court case, the Janice case. So I just want to take a minute and talk about what the Janice case was and how it changed the law. Okay. In New York State, for example, a public employee has no choice but to join a union. It's built into the Taylor law. And as being a member of a union, you have to pay dues. The dues go into the union, and then the union spends it on a variety of things. The two biggest categories within it is the costs of collective bargaining, the actual costs of sitting down and negotiating with, in my case, the school district for wages and benefits and all the things that go along with collective bargaining. It also includes the cost for defending certain members of the union should they want to file a grievance, should they get in trouble, and they need to, and there's some kind of action taken against them to discipline them in some way. So those are the traditional parts of the dues that a union uses the dues force to pay for. But unions are also permitted to take political positions as well. They can back candidates, for example. As far back as the 1970s, the law in the United States was typically that a member could only opt out of that portion of their dues that supported political positions, that the cost of collective bargaining was something they benefited from, and they had no choice but to pay dues into that. But if they wanted to, because they're free, we're talking about speech now, and no one can compel speech. A public institution, a government can't compel speech. The court said, for that you can sort of opt out, and you don't have to pay that small portion of your dues for that. Well, Janice changed that, okay? Now, under Janice, without going into too much of the details, no member can be compelled to pay any portion of their dues. So sure, they don't have to pay for that portion that supports, political positions, but they also don't have to pay that portion of the dues that supports collective bargaining. The reasoning, the court said, was that everything a union does can be considered to be some form of speech. Even the act of collective bargaining, the proposals that are decided to be taken to push forward, the things that a union is willing to accept from the school district in negotiations, everything is speech, and no one connected with a public entity should be compelled to support one thing or another. What does that mean for us? Well, we don't know. It's really brand new. Will people in public sector unions in New York, for example, start to withhold dues? I don't know. I can tell you that in the union that I was in, nobody stopped paying dues after the decision. The future, we'll see. Okay. All right. Let's move on to the second part, which is a very, very quick history of union unrest or labor unrest in New York City in the 1960s. In 1960, the United Federation of Teachers, or the UFT, was formed. And as you can see, almost immediately, they went out on strike because the city refused to recognize their union. It's hard to convince a group of people not to strike or not to engage in some kind of job action when the other side, management, refuses to even sit down and speak with them. So a year later, once again, high school teachers went out on strike in New York City. A year later, in 1962, once again, teachers walked out for a day over a contract deadlock. Contract deadlock is just a fancy way of saying they couldn't move forward on their contract negotiations. They had nowhere to go. They couldn't resolve it in any way. Impasse resolution procedures under the law at the time were ineffective. If the two sides can't be sort of compelled to come to some resolution on their own, or if there's no procedure in place to come to some kind of resolution, obviously the system doesn't work, and they went out on strike. A couple of years later, we'll leave the teachers alone for a while. In the New York City Department of Welfare employees, specifically social workers, went out on strike for almost a month. They were obviously they were asking for better pay, and they were also asking for a reduced caseload. They claimed that the amount of cases that they had to cover exceeded the federal guidelines by over 50%. And you can see under the law at the time, workers were dismissed, union officials were jailed. It was a mess, okay? And it always comes up when this is happening, when you're negotiating and parties aren't really making any headway or movement. Is there good faith? Are the parties negotiating in good faith at that time? A year later, New York City transit workers staged a 12-day strike, and you can see there was enormous economic loss to the city, not to mention inconvenience. When the buses and the trains aren't working, you really don't have a lot of choices of how to get to work. You're either walking across, I think in this case, that's the Brooklyn Bridge, or you're snarled in traffic somewhere on your way into Manhattan. So it's not something you want. Well, all of these strikes together finally got the legislature moving. And in 1967, the legislature passed and Governor Rockefeller signed into law the Public Employees Fair Employment Act. Okay, we call it the Taylor Law. And it's a direct result of the labor unrest of the previous years that we sort of just went through. Okay, forgive me, but the lawyer in me has to look at the statute a little bit to understand what its purpose was and what it tried to achieve. Section 200, which is the first part of the law, really lays out the reason why the law was put into effect. And that was to promote harmonious and cooperative relationships between government and its employees and to protect the public. Okay, that extra part is something very special for public employees, right? So that's something that's very important in the law. And it has about 5 subtopics. Number one, it grants public employees the right to organize and to be represented. If you remember back to that first 1960s teacher strike, the reason the teachers went out on strike is because the city even refused to recognize the union on the other side of the bargaining table. So under the present law, if you do all this, you fill out the right forms, you dot your I's, you cross your T's, and you are certified as, the representative of a group of workers, public employees, the municipality, the school district, the city has no real choice. They have to sit down and negotiate with you. It requires state, local governments, and other political subdivisions to negotiate and enter into written agreements. In other words, it guarantees the right of collective bargaining, which is probably the most powerful right that a union has with its employer. Now, the law itself encourages public employees and their employers to agree upon procedures for resolving disputes. The government would rather not get involved in resolving impasses, but there is a procedure in place, as we'll see in a bit, to do that in the event that the parties can't resolve their differences on their own. Let me just skip D for a second and go to E. It does continue the prohibition against strikes by public employees, and it provides the specific remedies for the violations of if a union should go out on strike. So this is really no change from prior laws. We simply don't want police, fire, sanitation, and in the case of New York, teachers from going out on strike. So what did they get in return? Well, of course, they got the right to collectively bargain, and they got the right to be recognized as a union. But probably the thing that sort of ties this all together is it created an administrative agency called the Public Employment Relations Board, or PERB, to assist in resolving disputes between public employees and public employers. So we'll see in a bit, we can call on PERB to sort of push the parties forward. And in the event that one party to the negotiations is violating the Taylor law, it is PERB who you petition to try to resolve that. Okay. One more part of the statute that's worth looking at, and that's the statute that defines what an improper practice is. Very simple. An improper practice means you're violating the Taylor law. So if there's something in the Taylor law that you should be doing or you shouldn't be doing, and you don't do it, then you are committing an improper practice, and parties can petition PERB to try to resolve the issue. But the thing about 209A is letter D, which I find most important. It is an improper practice for a public employer or its agents to deliberately refuse to negotiate in good faith. The statute itself compels good faith. It requires good faith. And we'll see in a bit how that plays out. Okay. So how does the Taylor law endeavor to ensure good faith? Well, let's look at a few kind of examples. So if you look at sort of the left side of the chart, the allegations being made that, for example, the school district is refusing to negotiate in good faith. The union wants to refer the matter to PERB, and they want them to issue an improper practice and force them back into compliance. What does it mean to not to negotiate in good faith? So, for example, if the union puts forward a valid proposal, something like, for example, we would like a cost of living adjustment, let's say equal to the inflation rate, or maybe 2% or 1.5%, and the school district comes back and says, nope, we're not going to discuss raises, that's just not on the table. Well, refusing to discuss a proposal that's appropriate is considered not negotiating in good faith, and it could be an improper practice. Now, it works the other way as well. If the school district wants to, for example, increase the employee's contribution to insurance, for example, let's say the district pays 90% of insurance, but it's very expensive, and they want to up it to 15%. If the union comes back and says, no, we're not interested in doing that, let's move on, that could be considered refusal to negotiate in good faith and be considered an improper practice. The next thing at the bottom there talks about fails to recognize a certified bargaining union. That's kind of a simple one. If the bargaining union, filled out all the right forms and, like I said before, crosses all the T's, dots all the I's, the city has no chance. The school district has no choice. They have to sit down and negotiate with that unit. Now, at the before we get to the red part at the bottom, let's just take a look at the middle there. There is a very, very detailed procedure of what happens when the parties cannot move forward in the negotiation process. Obviously, the parties are encouraged to resolve it on their own. But if not, PERB can step in either on its own or through a petition and order mediation, fact-finding panels. They can make recommendations, and in some cases, and with certain unions, certain bargaining units, they can order compulsory arbitration as well. Okay, let's move on to the next thing. Fails to enforce a contract provision after the contract has expired. Contracts do have terms. The ones that I were involved in usually were 3-year contracts. That was always our goal. Sometimes we ended up with 2, and every now and then we had to do just 1-year rollovers. But nevertheless, there was a beginning point and there was an ending point. So question arose very, very early on after the Taylor Law was created. Well, what happens to all of the rights in a contract, obligations as well, after the term of the contract expires, but before a successor agreement is agreed to? Okay, so let's take a look at that very question. And it arose in a case that we call the Triborough case. And that case was decided by PERB, and PERB is an administrative agency, so they have quasi-legislative powers and quasi-judicial powers as well. So PERB heard this case, the Triborough case, and the issue before the court was whether the employer acted in bad faith, therefore an improper practice, when it refused to pay a contractual increment due under the expired contract for years of service. The employer kept paying salary, kept paying fringe benefits at the level in the expired contract, but it refused to pay an increment to employees on the anniversary of their being employed there. So what does that mean? Let's look at a salary table from the contract that one of the contracts that I was involved in. And this is sort of a typical, sort of government salary schedule. Along the left side, you can see steps that usually represents the years of service. I don't know if the arrow is working for everyone, but if you take a look at like step 9, it usually means that someone has been working in the district for 9 years. And in the case of school districts, you also get paid based on your educational achievement. So here we have a bachelor's degree, a master's degree, and a doctoral degree, along with some other intermediary steps. So let's say somebody was working there 9 years, had a master's degree, and their salary was just under $85,000. Let's say this contract expired at the end of the school year, so that would be June 2018. When they showed up in September of 2018, did they automatically go to the $95,000 if the contract had expired? Or are they stuck at $84,000 or $85,000? Or similarly, if they were at 9 at $85,000, and over the course of, say, the summer, they earned their doctoral degree, did they automatically move from 85 to 106 in September, even though the contract had expired? Well, in the Triborough decision, the municipality took the argument that the employee was frozen at the salary level of the contract until there was a new contract agreed to. Whereas the union took the position that this whole table had been negotiated and agreed to prior to that, and increments should be granted until a new contract is agreed to. Well, what did the PERB say? Well, PERB said that given that a union, a public employee union, gives up its right to strike, that it imposes a correlative duty upon the public employer to refrain from altering the terms of the contract unilaterally during negotiations. An employee organization which does not strike is entitled to the maintenance of the status quo during negotiations. The decision basically imposes an obligation of good faith. The parties are frozen into what they had agreed to in the last contract until and until a new contract is agreed to by both sides. Now, about 10 years later, after the Triborough decision, the New York State Legislature enacted it and codified it and added it as an amendment to the Taylor law. So section 209A, here 1E, it is an improper practice to refuse to continue all the terms of an expired agreement until a new agreement is negotiated. As you can imagine, it's not a favorite of school boards. School boards is what I can speak to because I represented a school district, a union in a school district. And you can see that I sort of lifted this excerpt from a 2012 newsletter from the New York State School Boards Association, which obviously represents school boards across the state. And you can see one of the reforms they want is to reform the Triborough Amendment to eliminate automatic step and lane increases during expired contractual periods. I mean, they argue, and they are correct, that personnel costs make up, over 70% of, all school budgets. And if you allow these increments to go in effect, you take a lot of sort of negotiating room away from school districts. But to date, the Triborough Amendment is safe, and school districts and their employees can rest assured that all the terms and conditions of a contract will remain in effect until a new contract is agreed to. Okay, so it's nice to have something like the Taylor Law, which sort of requires good faith. But that doesn't mean that participants in negotiations, even within the Taylor Law, can't take steps to achieve good faith on their own. So I just want to tell you a few of the things that I always tried to do when we negotiated. The first thing I always wanted to do is develop a personal relationship with the opposing lead negotiator. I remember the first time I met the person who sat at the other end of the table with me. We had lunch together, and we got to know each other. And most importantly, we sort of got to trust one another. So when things were getting a little, spicy at the table, and we needed to talk sort of outside of the hearing of other people on the negotiating teams, and I said to him, look, I understand where you're coming from, but I have to tell you, it's not going to happen. That I can trust that he believed me. And the same is true the other way. If he said, look, our side is really tough on this, trust me here, I can give on other issues, but this one I have to have, again, I could believe him. Next, we always tried to establish ground rules, and we stuck with them. A very simple example is confidentiality. All the things that we talk about at the table stay at the table. We don't talk about them outside. It's very difficult. Members want to know what's going on, and you have to say, sorry, we've agreed to not speak about it. Nothing could, be worse for a good faith negotiations than to have rumors leak out, and then you're dealing with, just tracking down rumors and trying to set everybody straight. We always found that alternating where negotiation sessions take place is a good idea. It's not so much about home court advantage as it is just being good hosts. When you're a host, you have a different attitude. You want to make the people who come to your place of business or your home feel comfortable. We served food before meetings. We sat and talked with the other team. Our team and the other team would talk together about really anything that had to do with anything other than negotiations, children, sports. Again, the whole idea is to develop some kind of working relationship and trust with the other side so that when you get to these really sticky, thorny issues, that the other side is not really trying to take advantage of you. I always like to, explain my concerns and priorities in general terms. There is plenty of time to get to the nitty-gritty, the dots, the crossing of the T's and the I's, but they should know what your general, ideas are. Don't react to hard positions or seemingly unacceptable proposals. No eye rolls, no, grunts. Try to keep it as businesslike as possible. Listen carefully, ask good questions. Sometimes you can really get to the core of what the other side really wants, even though the way they're asking for it is offensive to you. Make counter proposals. Maybe you can get to yes by simply making a counter proposal after you've asked your questions and listened carefully. Remind them that you really just like them, you're representing your membership. It's not personal. And of course, at all possible, try to leave your emotions at the door. It is business. Just sort of circling back, an orderly way to resolving disputes. The Taylor Law tries that. It's the first thing it tries to do is to get parties to create their own procedures. Maybe mediation, arbitration, maybe settlement conferences. But if they can't resolve their own problem, they can't resolve these things on their own, there's always PERB to appoint a mediator, appoint a fact-finding board, and ultimately perhaps even arbitration. So just by way of sort of summing up here, the Taylor Law has had a positive effect on maintaining labor peace. New York doesn't suffer from the same strikes that it did in the 1960s, so there was definitely a positive change. Some of the provisions of the Taylor Law are instructive for all professionals in the world of negotiation and conflict resolution, and they include things like insisting on good faith. It's hard to resolve conflicts when you negotiate in bad faith. And then, of course, by providing pre-established impasse procedures in case you can't move the ball forward, there's some kind of procedure there to help you out. So I think with that, I'm going to sort of turn it back to Beth if she has any questions or any questions that have come in.
Great. Thanks so much, Michael. So a couple of reflections as you were speaking about your experiences and some of the other information there. I'm just going to start back with, I have a couple of notes here. So one of them, which I was really happy to hear you say, was about establishing relationship. And I've worked with organizations before where there are labor unions. And what always struck me as something very odd is that during the course of the year, or if it's a yearly or 2 years, there wouldn't be much effort made about going across the table, so to speak, and trying to build a relationship. And then when the contract time would come around, everybody was already gearing up for a fight, and they didn't have the rest of the year that they were working on to build that relationship. So I always thought, isn't that strange? That if you had a relationship, then wouldn't it make the negotiation smoother? And you spoke to that.
I think you got it right on. It came to us in different ways. So when we were at the negotiation table, I'd often have to, when I was sitting with my team during negotiations, I'd often have to remind them that, we kind of get together, for 2 months, 2.5 months every 3 years and, sort of hack out this new agreement. But the truth is, the rest of the time, the two sides have to have a working relationship. So you don't want to, you don't want to overreach in what you're asking for, even if you can get it. Even if in the end you can somehow coerce the other side into agreeing to a proposal that they really don't want, you don't really want to do that as a general rule, because you're not going to have a fun time, the other 2 years and 8 months when you're actually needing to deal with, management in this case on a day-to-day basis. And a lot of the things that go on, most of the things that go on happen with a phone call. And you certainly want to maintain that kind of relationship with, the school district and not lose it and ruin it just because of negotiations. So I agree 100%.
Right. Another point I noticed at the beginning when you were speaking, you were talking about how with the union that you represented, it was really a hodgepodge of people and roles and all that. And I just thought about the complexity of the different interests and issues that were being faced. And to me, that just added to it, didn't it?
Yeah, well, what's funny is we usually sat down with, across the negotiating table, in the year that the contract was expiring, we probably sat down with the other side, say in February. The school year, begins in September. But from September through February, my job was to pull together, the interests of this really, really diverse union in 2 ways. First of all, I had to assemble a team because we negotiated, at a table with a team. It wasn't just myself. So I had to first, pull together a team that was somewhat representative of this diverse union. Not every title, not every job could possibly be there, unless, there'd be, 25 people at the table just from our side. But I had to bring together a diverse group. And then having brought the diverse group together, the proposals that we actually would put down on paper that would eventually be given to the other side as we sat down to negotiate had to be pared down. I mean, you know, with a union of 1,300 employees, you can have, you know, 100, 150 different possible proposals each year or each contract to try to change the contract in some way. You got to take that 100 and bring it down to a manageable number, you know, somewhere between, you know, 15 and 25. Well, as you work your way through eliminating things, you're not making people happy, because, you know, things that you're eliminating might be very special to one part of this diverse union, and you know, sort of making one part happy but the other part not so happy. So yeah, so for me, I used to say that the hardest part of my job was actually bringing, you know, the union together and creating, you know, one, you know, sort of listing of proposals well before we ever sat down with the other side.
Right. So I'm glad you were talking about that, because that really stresses the importance of preparation and the fact that when you are at the table, that's just one part. So much has gone on before that to even get to the table the way you want to get to the table.
Yeah, absolutely. I mean, research is, you know, probably, you know, the most important part of preparation. I mean, to ask, you know, that was another, you know, kind of, you know, thing that would come up at just with our side is, you know, for example, if we were asking for a raise and they wanted X amount as a percentage, and, you know, it was only research where I could come back and say, wait a minute, we're not even going to ask for that because nobody is getting that. And it would just be bad faith to ask for it, because the only thing the other side is going to say is, why are you asking for that? Nobody in Westchester County has gotten that for 20 years. Right. So research is very important in sort of shaping people's expectations as well. And it really moves towards good faith, you know, as well.
Now, one more comment I have is you're mentioning a lot about collective bargaining. And I know that in the past couple of years, a while back, you know, Wisconsin had a big deal about collective bargaining, and there are some states that don't allow it for certain groups. So in place of collective bargaining in the states where it's not permitted, let's say for teachers, what happens instead? How do they negotiate for what they want?
Well, I have to admit that that's not, you know, my expertise, you know, area. But from what I've seen is, so for example, I know in Wisconsin, what they did was they limited the rights of collective bargaining. Mm-hmm. I don't see how, you know, a union, if a union is able to exist at all, how there can be no collective bargaining. But I know they limited, for example, you know, how often there can be a contract. They limited, I think, also how much salaries could go up in a given year. But to be honest, I mean, just think of the union that I described with 1,300 members. I don't think it's possible for a school district to negotiate individually with anybody. It has to be some kind of collective. So that's a great question.
Yeah. So now we'd like to open it up to people to please write in the Q&A box any questions or comments or reflections. We're happy to also hear about your experiences in this area if you have any. And we have, you know, some more time to be able to address that. So let's see what some people might say. So also, Michael, while we're waiting for that, is there anything else you might want to add that you've thought about now, or based on our conversation, or other things happening that you think might be interesting for our audience?
Well, I can only reflect back to some of the things that, you know, that I experienced during the last 15 years. Something that I didn't mention earlier, and this sort of plays towards parties sort of resolving their differences on their own, is within our collective bargaining agreement. I don't think it's unique at all, but there was a very, very detailed procedure of how to resolve grievances. So for those who don't know, when you're talking about a collective bargaining agreement, a grievance is simply the equivalent of somebody, claiming that the contract has been breached. So, you know, you're not going to start a, contract lawsuit, litigation for breach of contract, but the contract itself sort of accommodates that. You file a grievance, you claim that a provision of the contract isn't being respected, and then it ultimately could potentially, in our contract, end up with an arbitrator. But I have to say, in the 20 years that I was there, and not even as a negotiations chairperson, I think maybe once or twice it ever got to an arbitrator, because the mechanism within the contract itself allowed the parties to sort of work it out and settle it to everybody's sort of satisfaction. I was involved in one of those settlements. We had negotiated something in the contract that ended up being really, really complicated, and to be fair, really dumb. It was hard to enforce. It was vague. And then when people tried to take advantage of that right, it got complicated and there was disagreement. So we had to come up with some kind of settlement so it wouldn't go to arbitration. And we sort of all winked at each other and said, look, let's just get through this. The contract's going to expire in a year, and when we get to the new negotiations, we'll fix it there. So, it's very important.
Yeah. Great. So we have some questions here from people listening, and one person's asking, while moving to the right on the first slide, and I guess they mean the continuum of negotiation approaches, can we state that it gets more expensive? I'm going to say yes, because what happens is now you have third parties involved. And then depending on who the third party is and what the process is and how much time and effort, research, and so on that person has to do, then usually I would say that people pay for this because that's their profession. That's what they charge for. So I would say yes, that it does get more expensive as you go towards arbitration and litigation. Do you have a comment about that, Michael?
Sure. It gets more expensive. It's more time consuming, right? And as the continuum shows, you lose control of the decision. But the expensive part of it is definitely important. I know when everybody sort of knows these sort of stories of how, teachers in New York State that have tenure, how difficult it is for a school district to fire them, to remove them for cause, because they have rights, they have due process rights, which means that there's going to be a hearing, there's going to be evidence, there's going to be an arbitrator, or a hearing officer. It's going to take time. And, even school districts who really want to get rid of, an employee who doesn't deserve to be a teacher will do whatever they can sometimes to settle the case short of that. Because yes, it takes time, it takes a lot of money, and you never know what the result's going to be.
Mm-hmm. Great. Now, here's another question. I think you kind of alluded to this, but maybe there's more you want to say about it. How did you balance the needs of the multiple groups when they were under one union, the one you talked about at the start of the group? So I think that's the one where you had that, the union with the teachers and the secretaries and everybody in there.
Yeah, like I said, I think that was probably the most challenging part of the job. At least I perceive that to be the most challenging part of the job. A lot of it was made easier because if you bring the right team to the table, in our case, if you make sure there's teachers there, there's people from the trades, meaning, carpenters and electricians, and others, you look to them for guidance as far as whether a particular proposal is truly a priority of that group or not. And you take that as part of your, one data point as trying to decide what to keep and what to sort of cast away. You also, one of the things I used to do is when the suggested proposals sort of came in, I always did at the beginning of the school year, sort of like a survey or some way for the membership to send me how they think the contract should be changed or what provisions in the contract should be maintained. And I cataloged them very, very carefully so that, if one particular proposal was reoccurring and, 10 people, 20 people were saying the same things, well, those kind of proposals took on more urgency. But, if there was a one-off, somebody, said something and was like, well, that's the only one who brought this up, maybe the priority dropped a bit. All of these things kind of went into the mix. No one thing worked, was determinative. Another thing we did often was to sort of create a matrix of what are the proposals that are most likely to be agreed to, versus what are the what are the proposals that are most, or the hardest, the most difficult to get, or the most pervasive across. So we sort of move things around. We tried to pick the proposals that affected the most people, that were also the easiest, the lowest hanging fruit to get, for example. But I will tell you, it was the biggest challenge to listen to people with very, very diverse opinions and come from very, very different places, and try to create something. We always try to put something in there for most of the groups. There was something that we can say, this is for you guys, this is for you guys. But I will admit one thing. The one proposal that binds everybody together in one of these things is a good raise. So in the end, when you come to a resolution and you have a contract and you bring it to you show it to the membership to ratify, the first thing everybody looks for is, what's the raise? And if it's a good enough raise, the other provisions usually are less important to them.
So funny how things shift. So one more question I have, and that is, we can't look at these kinds of negotiations in isolation from the rest of the context. And what I mean by that is, beforehand, you have whatever feelings, emotions, and preparations take place, and then you have the actual negotiations, for better or for worse, however they turn out. But then the day after, and after that, you have to go back to the same workplace and work with people who you may have been on the opposite side of the table from, and maybe things did not go the way you wanted to, but you still have to be in the same environment working. And I'm curious, from your experience, what, if anything, has been done about, in some cases, repairing relationships and fostering a good or decent working environment?
Well, I think one of the things we always try to do is, certainly before the ratification vote, we would always hold sort of, we'd have meetings to tell the membership exactly what it is we agreed to, and explain it to them. And when there was some expectations of maybe achieving something better, and that didn't happen, explain to them, why that didn't happen. There were always people who were unhappy. They tended to be the same people year after year after year. I will say that. But, good communication went a long way in explaining and making people feel better about certain things that we didn't get that we should have gotten. The other thing that we did, and we started to do this towards the end, when I was the last, several years, because the environment was getting harder and harder because school districts, their budgets were tighter and tighter. What we started to do is tell them what the school district was asking for that we were able to say no to. And when we started to list all the things that we were able to protect them from, some of the people who were unhappy started to say, well, okay, I understand. Thank you for that. I know I didn't get the raise I wanted. I know I didn't get, I know that, we're paying a little bit more on our, health insurance, but, I'm only paying 15% now. I didn't realize they were asking to pay 25%. And that also went a long way in sort of making people feel better.
Yeah, so transparency is important.
Yeah.
We have some more here. Let's see if we can move through these quickly since we don't have too much time. I'm not sure how you can address this next one, but it says, culturally, it is different to negotiate in different states across the USA. Have you seen some challenges in this space, especially in the union space? So I guess, how would you negotiate union work in different cultures of the different states?
Yeah. I don't know if I'm the one to answer that. I look at what happens in other places across the country, and I really throw my hands up and wonder how negotiators for those unions really, approach the table and how they approach their job. I was very fortunate because at the bottom line was the school district understood that we were all there to provide a good, public school education for students. And we heard many times during the time that I was a negotiator that, where the rubber meets the road, is where there's a teacher in a classroom with a student. With that kind of an attitude, it wasn't that hard to find some common ground. In other states where, there's such a mistrust and, with unions in general, I can't imagine the challenges that those negotiators have to go through.
Yeah. And maybe one more question here. This is kind of an interesting one too. What advice would you give to someone trying to start out in mediation or labor negotiations? I live outside of New York, the Boston area. Also, what advice would you give yourself from when you started? So it's a little bit of advice category.
Well, it's kind of funny because when I started, I think I mentioned at the very beginning, I didn't really have I didn't have any labor negotiating experience at all. I mean, I did, practice law for a while, and there was some litigation negotiation as, we did some settlement conversations we would have, but it really wasn't something that I was trained in. And when I took on this role, I don't know who recommended it to me. One of the first things that was recommended was a book that someone gave me, and I'm sure you would know it. And the book was Getting to Yes. Which was negotiating agreement without giving in by Roger Fisher and William Ury. And I remember reading it, and it really started, my understanding of what it's like to sit at sort of a negotiating table where you're doing more than just, say, negotiating with a car dealer to buy a car. Other than that, there were conferences that the New York State United Teachers gave that I went to one of those to learn a little bit. As a lawyer, I have to continue my legal education, so I've gone to negotiating seminars over the years to, sort of keep the edge and learn new things. So there are really good books out there. There are seminars out there that can help people, sort of hone the craft of negotiator. And I would recommend, whatever you can do, you should.
Okay, there's one more comment here somebody made. It's more a comment than a question. It says, your comment about establishing a relationship of foundational interpersonal trust is particularly valuable. Before law school, I had been a mediator of business and community disputes, and I took a job outside of my prior work. I was asked to join the collective bargaining team. The contract negotiations became heated. For the next meeting, I brought some coffee and pastries for everyone. I hated the opposition's team. Oh, no, I handed, not hated. The opposition's team leader a coffee that he liked. I researched his coffee likes with the local coffee shop. The negotiations were less heated. I was made chief negotiator. We achieved all the core desired results and some extras. So you're right. So good coffee, and definitely know their coffee preferences plays a role there.
Food is definitely a good tactic.
Certainly is. Well, we're out of time right now, but thank you so much, Michael, for all of your contribution here, and it's very valuable. And Andy will come back on and tell us about how to access the link. Thank you, everybody, for listening.
You're welcome.
Yeah, no problem. And, thank you for everyone that was participating in our webinar this afternoon. As a reminder, the webinar was recorded, and I will be making it available to all of our registrants online in about the next day or two. So thanks again, and have a wonderful rest of your day.
Thank you, everybody.